Hi, everyone, and welcome to today's webinar. My name is Anna, and I'm with the New Mexico Small Business Development Center. Today, we have Larry Donahue joining us, who is a seasoned high-tech business executive and 30-year attorney. Larry will be presenting Registered Your Trademark, Now What? We will be using the Q&A function to take questions and welcome attendee participation, so don't hesitate to ask us any questions you may have. We will answer those questions during and at the end of the webinar. Thanks so much for joining us. And without further ado, I'll hand it over to you, Larry.
Thank you so much. Thanks for having me. I appreciate it. And I appreciate everybody joining us right now. And if you're somebody looking at a replay or watching this on YouTube or on the internet, I appreciate your looking this over. And if you have questions, of course, please contact me or the SBDC. And the SBDC is going to be able to get you to the right people or individuals, as well as make our presentation available to you if you'd like a copy of it. So without further ado, let's talk about trademarks. And before we do, a couple of quick administrative things. One is there's a lot of COVID related information out there. And I'm really sorry to say this, but we still have a pandemic going on. And I know you're probably absolutely tired of it. And it's just shocking that it's a political issue, but as a business owner, you know, what you care about is not having to deal with BS and more expenses. And so the quick, you know, path to that is you follow CDC guidelines, whether you think you're a doctor and agree or disagree, just follow CDC guidelines, and that's going to be the best defense against any potential negligence action or some other issue that eventually hits you. These resources here are great, and you don't have to write them down now. You can ask for a copy of the presentation and get access to these links with the presentation by contacting the SBDC. My name is Larry Donahue. I'm going to be dealing with this presentation today. A couple of quick things around this. If you set your zoom ratio to fit window, it'll make the text clearest so that you'll be able to read it easily enough. I'm also a guy that likes to have interaction. The problem with trademark law is I could literally talk about this for an entire week, and I'm going to condense this down into an hour. So the question becomes, how savvy and sophisticated is the viewer? And I'm just making a lot of guesses here. So if I am talking to high level and need me to dive down into somewhere, please feel free to ask, and I will modify accordingly. And finally, what are we going to be talking about specifically? Well, we're going to be addressing trademarks, specifically how to enforce and protect and police your existing mark. And it's important to understand a little bit about trademark law. What is a trademark? What is likelihood of confusion? It's important to understand these concepts in order for you to effectively police and enforce your trademark. And you might be asking, why do you need to do that? If you have a trademark, isn't that all you need to do? And the answer is there's a lot of issues around that. And so we're going to explain those so you have a better understanding of what those issues are. Specifically in 3 areas, we're going to talk about trademark law in general, how and why to police and enforce your trademark, and then understand a little bit how to hire the right service to help you if you think you need help doing this versus doing it yourself. So let me start with, you know, and you probably already know this to some extent, what is a trademark? But I want to spend a little bit of time discussing a trademark just to remind everybody what it is here we're trying to protect, as well as what is it we're looking for out in the rest of the world to protect our mark against, you know, to decide whether this is an infringing activity or not. So a trademark is a identifier that associates with a product or service. It could be a word, it could be a logo, a graphic, a color, a sound. So I'm gonna, you know, throw some stuff up here, you know, and look what I did, the golden arches. And you know exactly who I'm talking about, don't you? That's what a trademark is. It's that association with a particular product or service. That's what a trademark is. So, right, Apple computers, and the swoosh, right? Everybody should know what the swoosh is. These are, ingrained in society because they've spent a lot of money using these marks in advertising in the marketplace and developing brands around it. But it's more than just a logo. It could also be a color. So if you've seen a green garbage truck driving around, that's probably going to be waste management. If it's not, there's probably infringing activity. I, interestingly enough, had to deal with color, not for a garbage truck, but for a septic pump system. So you would see these yellow septic trucks zooming around, but it wasn't just the fact that they were yellow. They actually looked like a school bus. They were calling it stool bus, kind of a play on the word. It was kind of clever. The problem was it was too clever, and everybody was wanting to use it. And my poor client, who literally had this clever branding out in the middle of nowhere, New Mexico, having to spend tens of thousands of dollars enforcing and policing his trademark. So it's really interesting how, you need to understand that it's not just simply getting a trademark that's important, but all the other aspects with it in order to maintain its value and maintain the brand. What about this? Pink fiberglass. You may or may not know that's Owens Corning, but they've dyed their fiberglass that color specifically, for a branding exercise, and that is protectable, and that's what they're doing. But would these be okay? If I took the golden arches and moved them, I just turned them 90 degrees, is that okay? I hope you're thinking, no, it's not okay. But it's not the same mark, is it? It's different. So what I want to stress to you is that simply by making changes to an existing trademark doesn't necessarily all of a sudden make it okay to use. And that's important because sameness is not the test. Similarity is the test. Is it similar to? Does it look similar? Does it sound similar? Does it mean similar? That's what's important, and that's what's really hard about this. And you are going to have to be in the driver's seat as somebody who owns a trademark to try and evaluate whether we got an issue or not. And if we have an issue, then what are you going to do about it? So, just simply modifying stuff. I've seen it all. I've seen people try to change the color of a logo and use it and think that that's okay. And it's not. It doesn't matter, even though you have color out there in trademarks like the golden arches, it doesn't matter. McDonald's is still going to have a problem if you use the similar arches with a different color. But if you have a green garbage truck and you want to paint your garbage truck blue, that's okay. So trademark law is very complicated depending on the circumstances and the issues. But it uniquely identifies the source of a product or service. So that's really the key. What is it identifying? And you have a bunch of rules around this. It cannot be confusingly similar. It cannot be descriptive. And that's going to be something else that's going to be interesting and challenging for you. You might have your mark and somebody else is going to try and use it, and they're going to try and throw up descriptive terms around it and say that they're not using your mark. I'm going to help you understand how to evaluate that to determine whether you need to go after them. And why is that important? Because you got to spend money on a lawyer. And you probably have better things to do with your money than spend money on a lawyer. And if you don't, then I'm happy to take your money and work for you. So dollars are generally precious, and we want to avoid spending dollars if we can. And so that means you need to understand these concepts or issues. There are a bunch of other rules around trademarks. They can't be immoral or scandalous. They cannot be geographically significant. They can't be a surname or a portrait or a signature of a living person or a deceased president. They can't be deceptive or falsely suggest a connotation to something else. Can't be a coat of arms or insignia. These rules, though, apply to trademarks. So it's possible people are going to use these things. They're going to use an immoral word in their company name. And, that's okay, as long as it doesn't infringe on your mark and it doesn't affect you. They can do that. They're not going to be able to get a trademark. They're not going to be able to protect it themselves, but they can still use it. So there's two kind of classes here. There's classes of trademarks, protectable names, and then there's everything else, whether it's trademarked or not. Now, in your category, if you own a trademark, you care about both sets, but it's also important to understand when you cannot protect a particular name or mark, because that is going to be a huge factor in whether that is going to be infringing on your mark. And I'll explain what I mean a little further. There are some names, by the way, that are protected by statute. And one example would be Olympic or Olympics. That is a statutory or statutorily protected mark that cannot be used in the real world. So let's get to policing and enforcing your trademark. And the big question is, why do we care? Well, what I want you to do is think about how long and hard and expensive it was to obtain your federal trademark. This is really interesting to me because as a trademark lawyer, it's probably not going to come as a surprise to you, but I don't have 100% success rate. It's somewhere around 10, 15% failure rate. So I have somewhere around an 85, 90% success rate, but I'm not 100%. And the reason I'm not 100% is because my clients fall in love with something and they just want to go forward, try it, despite my warnings, despite me telling them this isn't going to fly, and here's why, or this is a high risk, and here's why. They still want to try it, and as a consequence, I'm not at 100%. But if you try it on your own, or you've hired a non-lawyer on the internet to do it, the failure rate is over 80%. So 80% of trademarks, we call them pro se applicants. Basically, you hire an internet company and they're like, oh, we're going to file you a trademark for you. What they don't tell you is, well, they take your information and it's like garbage in, garbage out, and they send in an application, but then they make you log in and sign it. So it's you actually putting in the application yourself based on the data they put in the form. And that has an over 80% failure rate. So if you went through that exercise, I'm sorry to hear that. Although you wouldn't have enjoyed working with me, because I go back and forth with my clients 50 times until we get the application right. And that can be a very frustrating process. But when we get through that process, then we got to wait 3 to 5 months pre-pandemic, 6 to 7 months post-pandemic, or if we're in the pandemic, that's where the USPTO is now. So after even getting through the application process, you got to wait a long time. So you spend a lot of time and effort getting that trademark. So the moment somebody uses something that's similar, we're going to use the word similar to your trademark, it's going to reduce the value of your trademark. It's going to reduce the value of all that work you put into making that mark and maintaining that mark. It's going to cause confusion in the marketplace. It's going to cause confusion with your customers. Heaven forbid if somebody using a confusingly similar mark to yours provides substandard services or does something wrong, says something crazy on the internet. I don't know if you've noticed in today's political environment, but people seem to lack a certain ability to, interpret things for themselves. They will, it seems to me, they'll read whatever garbage they find on the internet and then run with it and decide to send death threats over voicemail or email. And, so you don't want any bad association with anything that can be confusingly similar to your mark. You can't control it. You're going to have people out there just run with it, whether it's fair or not, whether it's true or not. So you would really like to avoid that. The other thing it does is it could block your attempt to expand. And so you may say today, look, all I care about are earrings. I don't care about anything else. Well, that's today. Can you really say you're not going to care about bracelets or, neck, charms and other piercings, other jewelry in 2 or 3 years? Or maybe not even jewelry, but types of clothing or glasses? You really have to ask yourself, is it a definite no in 2, 3, 5 years, or is it a maybe? If it's a maybe, you care about it. So, even if there's a confusingly similar mark out there and it's addressing something you don't care about today, the question is, might you care about it in a few years? And if so, you need to keep the room open and not let that happen. Another issue is in extreme cases, and I'm going to talk about this further, it can make your trademark unenforceable completely because it becomes descriptive. And it happens, believe it or not. And the issue with the stool bus I talked about, where people in the septic pumping industry are think it's just the coolest thing to paint their pump truck yellow and put school bus windows on it. All of a sudden the whole darn industry is doing that. Now what do? Now it becomes sort of a descriptive thing if we're not careful about it. So trademarks exist on a spectrum. And on the left, the red represents things we cannot trademark. They're descriptive or generic terms. If I open up the dictionary and look for the word apple, what is the definition of an apple? A fruit, right? Typically. So if we're talking about, apple pies or apple farms, those are descriptive. We can't pull them out of the dictionary. If I want to use the word apple for a computer company, well, darn right I can do that. But interestingly enough, if we don't protect our brand, what ends up happening is our mark starts sliding from the right to the left as more and more people start adopting or using the mark that we created for our company. And eventually it becomes unenforceable, unprotectable. And we're left with all this work and effort and money that is worthless. And I wonder if you can think of a couple of names that might have fallen in here. I'm going to give you a list now, and some of them are surprising, but you've heard of these names. Everybody has. Elevator, for instance. When I say the word elevator, what do you think of? You think of the thing. You don't think of a company, and that's the problem. So elevator used to be a trademark that has fallen into the dictionary and is no longer protectable. Escalator, same thing. Yo-yo. Aspirin. Aspirin is a generic term. Now, don't tell Bayer that, but aspirin is not a protectable name at this point. Cellophane is not. Trampoline, thermos, dry ice, laundromat, kerosene, linoleum, app store. It was a big fight with, I think it was Apple and I want to say Google on this, and eventually they withdrew the fight on it. But it's, generic term. Zip code, interestingly enough, zipper. All of these things are dictionary terms that used to be trademarked, and somebody was trying to protect a brand or a product with that. There was a whole nother list. I decided not to throw it up here that we lawyers talk about, that we say these trademark holders need to watch their backs because these names are so prolific in the marketplace. And the reason I decided not to throw it up here is because those trademark holders would certainly have an issue with me saying, you guys, it seems like you're going to have problems at some point. They want to fight that, and I don't want to fight that battle. But I'll give you one example. Google, right? Google, they're going to flip out hearing me say this, but they're already having challenges because people will use it as like a verb, right? Why don't you go Google that? See, what Google says about it. And that is the kiss of death. They have to fight very hard to make sure that it doesn't fall into the dictionary term of what it means to search a computer index. But there's many, many others. It's actually a very interesting area of the law, and these companies spend a lot of money to try and avoid that. And it doesn't just happen with the big guys. It can happen with you. And it can happen with you when you have a mark that is being used by others. And it doesn't have to be a lot of people either. So it's a very slippery slope. And the problem is you got to spend real money to defend your mark and police it. So that's really the issue here. So it's important to understand when you need to go on the attack. But the other issue is, do you need to go on the attack? That means you got to monitor, you got to define and figure out who is out there, right? You have to monitor the world of marks. And then if you find something that might be potentially infringing, then you need to go after them. And so that's what's really difficult for most people is one, the monitoring, and then the enforcement. So on the monitoring side of the fence here, or the coin, you need to look at the use in the public, the common law use. You know, that includes social media handles. If you haven't done it, you probably should. Go and get the relevant handles that match the word mark that you may be protecting, if possible. And if not, you need to examine who has your trademark, using it as a domain name, as a Twitter handle, as a Facebook extension, you know, on the name. You want to try and grab those and keep those and use those instead of letting somebody else get it. And if somebody else does have it, you need to evaluate whether their use is infringing use. I mentioned domain names and websites. Now you can use search engines for this, but I'll explain, there's a few other areas that you would probably want to use to monitor these things. The other area that we care a lot about are trademark registrations. We want to go after people and prevent them from getting a trademark if we believe they have an infringing mark they're trying to trademark. Fortunately, and if you've gone through this process, the USPTO has its own work in trying to do what they call a likelihood of confusion refusal. It's called a section 2B or 2D, I'm forgetting now, refusal, based on likelihood of confusion. So the USPTO does a pretty good job of filtering stuff out, but every once in a while they'll miss stuff. So you have to monitor that and prevent a infringing or potentially infringing mark from becoming a trademark. And then the biggest issue here are instances of actual confusion. And I want to spend a couple of minutes on this. If I did not put up the likelihood of confusion test, it's roughly 7 different elements. We're going to talk about some of it, but we're going to talk about it from the standpoint of similarity in look, meaning, and sound for the marks, because that's really important. That is going to capture 90% of the issues. But one of the elements of likelihood confusion is evidence of actual confusion. And so what this means is somebody's calling up your company saying, hey, I heard you just opened and I'd like to buy from you. And you're thinking, I haven't just opened. I've been around for 10 years. What are you thinking? And then they say, oh, I just saw a new ad. You looked up the ad and it's not you. So you have actual evidence of confusion there. And so while the ad is important because you can show, hey, look, you're infringing on my trademark by producing this ad, and that's important all by itself. But the call from the confused member of the public is gold for us lawyers. And so what I want you to do is whenever you get a call or an email or anything from somebody that is confused about what they saw and you and or your products or services, I want you to document that. What's the date? How did they reach you? What did they say? Try and get their name and contact information, because that is very, very important. And almost makes my job very easy when I say we have an infringement problem, are issues of actual confusion. And so I've seen instances where we'll have like a beauty salon, sit on a corner block somewhere for 20 years, and then one of the estheticians or beauticians leaves and opens up someplace around the block or around the street with not the same name, but what's the word? Similar name. And now people they're getting confused. They heard, they think Susie was in the name, but they're not sure which is which. And so then you get people showing up that are with appointments that are really for the other place. That's evidence of actual confusion. So they need to be documented in a log. And the more of that we have is great for infringement actions, but it's terrible for your business because each sign of actual confusion is a customer lost, is a diluted mark, and putting another checkbox on you're going to have to spend money with a lawyer to do something about it. So that's really important to document and keep records and the contact information, if possible, of the individual that showed confusion. So that is the monitoring side. And at the very last slide, I'm going to give you some other tips on how to dive into the nuts and bolts of doing monitoring, which is not easy and it's a big nightmare, but there are services that you can hire to help you, but I'll tell you about what to look for. But on the after monitoring, we have enforcement, meaning we found a potential infringer. Now what do we do? And the answer to that question is going to depend on the circumstances. So, if we see somebody out in the general public, somebody on Facebook using a similar name to yours, and they want to, you need to try and stop it. My advice would be to do it yourself first. Try and deal with it yourself without hiring lawyers to save money. And that would require having a really good C&D letter template and ideally prepared for you. The ones we do for our clients, we say it's on our client's letterhead. It's their template. They send it out themselves. I don't even know how many hundreds or thousands of these letters have gone out in the past, but it'll say something along the lines of, your mark located here is confusingly similar to my mark. It's a registered trademark. See registration number such and such. And I'm asking you business to business to stop the infringing use. I will give you 1 week. You need to report back to me and tell me what you did do. And I'm not going to pursue this further. But I have them list us as the law firm. My law firm is such and such. My next escalation is to them. If you don't do this, you will hear from them. And then you're going to be responsible for attorney's fees. You might have, we put some very specific language in there and cite to us as the law firm. And our clients have been getting great results with that because very few people want to pick a battle with a law firm. So they're going to back down, hopefully. Now, remember what you went through when you got your name, right? I'm betting you had kind of fallen in love with your name. It probably took you a little bit of time to find the right name. It's an emotional process for people, and it is for the infringer as well. And so it's really important to, get to them early. Number one, don't wait until it becomes a problem, right? Because if it becomes a big problem, that means they're really vested in it. They've spent a lot of money in it. And so now they're probably going to fight you, and that's going to cost money for you. So you got to hit them early, and you want to hit them with a really strong C&D, cease and desist letter if you can. And 95% of the time, my clients are able to get the other side to back down and find another name. And it's really interesting here because a lot of times you will find an infringer and they're just like a basic Facebook user. Maybe they're 18, 19 years old. So you feel bad. You're like, well, they're really, they don't really have much of a business anyway. And so there's this hesitancy I see in my clients because they're just decent people. You don't want to go and be yelling at everybody. And I get that. But I need to stress that you want to tackle this problem when it is small, so that the other side has an opportunity to change their name and brand when it's not a big deal for them either. I mean, they might be emotionally vested, but financially, it's still not a big deal. And that's the best time to get them to change. But if you wait a couple years, and now they went and spent $35,000 on an electric sign out in the front of their place, well, now you got a battle on your side. And when you hear that from an attorney, think expensive. You're going to have to, we might have to file a lawsuit to get them to stop. And while I want to talk about damages in a minute, you still got to file the lawsuit. You still got to pay a retainer. You still cash out of your pocket. So it's best to hit them early with a really good C&D letter is my point. I hope you're hearing from me. The C&D letter should have very specific deadlines, tight deadlines, not months, weeks. They need to respond and stop using immediately and respond back to you within a couple of weeks to verify that indeed they have stopped their infringing use. If that doesn't work, you really need to escalate to a law firm or attorney to then turn up the heat. So, if I were to give just raw, rough statistics, I would say our clients are generally somewhere around 90–95% successful dealing with it themselves. That other 5 to 10% gets to be a problem. So they hike it over to us, and then we're probably 80% successful ourselves in getting people to back down right away. The remaining 20%, well, of that, maybe 10% have their own lawyers. And we lawyers, I don't know if this is going to be a shock to you, but we get paid by the hour, and we get paid more money when we're fighting. So when I get a lawyer responding to me, invariably it's going to be a fight, and that costs money for my clients, of course, when I'm dealing with this. The other 10%, just, they don't care. I don't know, there's something, they're going to cut their nose off to spite their face. They're not going to return phone calls and necessitating a lawsuit. And even then, that's a real problem as well, right? Because who the heck are they? Where are they? We got to spend a lot of money to, extend the long arm of the law to, some rural area in Alabama. I mean, it could get really expensive quick. So another area, and this is really, really important, but it's also really hard to do, is the trademark registration side. So if you find out about a trademark registration, ideally, you want to fall into the process. And what I mean by that is, I mentioned earlier, it takes the USPTO 6 to 7 months to get back to you. It used to take 3 to 5 months. Now it's 6 to 7 months or thereabouts. When they get back to you, if they approve the trademark, what they say is, we've approved, we're going to publish for opposition soon. And then they will send you a notice of publication saying they're going to publish it at a specific time. And then they publish for opposition for 30 days. So you, as a trademark holder, have 30 days to file in opposition. And it's very inexpensive. You could do it yourself with the right template, and 90% of the people are going to back down and not fight. The other 10, you may have a fight on your hands, and then you need to hire a lawyer, but you're using USPTO, and it's a streamlined process, and therefore less expensive, easier, faster, versus dealing with the random court or federal court, depending on where the other party is. So you'd really want to take care of that. The problem is the 30 days. You don't know when, right? First of all, do you even know what marks are potentially confusingly similar to yours that the USPTO is looking at? And of those, do you know which ones the USPTO is going to approve and when they're going to be published for opposition? It's a very hard thing to know. So this is really why you need to be monitoring this at least monthly, ideally twice a month, because you need some time to submit the opposition. Or if you're going to hire somebody to do it, you want to give them at least a week or so. So if you're monitoring that just once a month, it creates the possibility that you might learn of something that is in day number 28 or 29 or even 30, the opposition period, not giving you enough time to actually file a formal opposition. Now, if you miss the period, it's a lot harder. It will eventually go to be published if nobody submitted an opposition. And then you have to seek cancellation of the trademark with the USPTO, which is a whole nother process and can be a lot more expensive. And you got to show a lot of interesting evidence as well. You had first use, all the affidavits you submitted were true and correct. It becomes a much more expensive process. Furthermore, if you do nothing for 5 years, they can file what's called incontestability with the US Patent and Trademark Office. The moment they do that and the USPTO approves, we lose our ability. There are some ways to deal with infringement, but it becomes really difficult to seek cancellation of the mark. So we don't want that to happen. You definitely don't want a potentially confusing trademark of another party sitting around and reaching that incontestability status. It doesn't happen automatically. A trademark holder has to submit the right documentation and pay the fee, but they can do that in 5 years of having the trademark registered. So finally, there's a thing I'm going to call gray area. And what that is where maybe it's a trademark, maybe it's not. You're not exactly sure if it's infringing or not, but you're okay with them using it, but you don't want it to get in the way of your business down the road. We have a thing called a coexistence agreement. So this is where you and the other trademark holder or other company can get together and say, okay, look, we think our marks are fine. We don't think there's infringement here between the marks, but we're making some promises to each other. One is, you're the new guy. There's no reason I need to sign this, so you need to make some promises to me. One of them is, you aren't going to move in these key business segments. 2, you're going to tell me if you find out about somebody infringing. 3, you're going to, not move outside of the bounds of this, or you're going to pay my legal fees. It gives you certain rights, but at the same time, it allows the other, company to move forward with their brand without potentially colliding with yours. And so that is a powerful mechanism almost to allow a coexistence, a legal coexistence, and give you, some protections as well as the other party. So I want you to be careful though when policing. And the reason being is that you could find yourself in a lawsuit if you're not careful, and if you are overextending yourself. And so what do I mean by that? Well, let's say you are producing items of clothing. That's class 25, and you've listed out your specific articles, hats, shirts, t-shirts, hoodies, pants. And you think maybe you want to go into jewelry someday, but you haven't yet. So you start going after other people that are using the same or similar name as yours in jewelry or other segments that aren't similar to clothing. Well, if you go and start enforcing your mark against somebody that has a little bit of money, they might come after you and do the reverse. And it's a really interesting problem. So here's why. If you are in clothing, that's class 25. I don't remember what class jewelry is, I'm sorry. But let's say there's another company using a similar mark in another category. Well, you guys are both doing your own thing in your various categories. And now you come along saying, hey, you need to get out of your jewelry category with my mark because you're confusingly similar. Well, if they have half a brain in their head, they're going to say, well, wait a minute. If you're saying clothing and jewelry are similar, then you're saying I'm infringing on you, you're infringing on me. I've been using as long or as longer than you. So why do I have to stop using? You need to stop using. So my point with this little example here is you just don't want to go and pick a fight somewhere. You really need to do your research and play 3D chess a bit. You don't want to pick on somebody bigger than you, number one. That two, if they use the same argument you use, could put you in a problem or a difficult place. So you need to understand the issues around all of this and then apply it when and where appropriate. And if you don't, then you could find yourself in a lawsuit because they will seek either cancellation of your mark or a declaratory judgment. Basically, that's going to a judge saying, hey, Your Honor, there's this dispute here on who has, the most rights, the precedent in the name. We want you, judge, to make a decision. And that means you have to fight for the right to keep your brand. You may not want to be in that situation. So you need to pick your fights and battles carefully. So let me give you some tips around all of that. We want to make sure that you pick the right fight. Now, before I do that, you need to know this. And this is why trademarks are so helpful, because they give you a big club. If you win, right? That's if you are able to prove a likelihood of confusion. You're able to prove trademark infringement. The law gives you a lot of tools in the belt, a lot of ammunition to deal with the other side, including what I've listed here: restraining order, attorney's fees, court costs, disgorging profits. Do you know what that means? It means you could ask them, force them to give you their financials. And if they made money, they have to pay you the money they made using your brand, infringing on your trademark. And furthermore, if you can prove you lost sales because of their infringing use, you can claim that as well. And finally, we have instances of willful infringement, which provides statutory damages, which are delightful. What is willful infringement? Well, you can't say you didn't know about this because here's my C&D letter I sent you 2 years ago that you ignored. Here's the email and follow-up I sent you 1 year ago that you ignored. You cannot say you didn't know about this, you ignored me. That's willful infringement. Now, on top of everything else I listed, we can also ask for statutory damages. So you get a lot to play with, but remember what I said, you got to pick your battles and make sure you're doing the right thing and not overextending yourself. And so as it relates to overextension, I want to dive in a little bit more on likelihood of confusion so you understand the issues. And this will help you because, if you don't understand this, you're either not going to send out the C&D letters when you need to, or you're going to be sending too many out. You're going to be on one of the tail ends of the bell curve, and you want to try and get in the middle if you can. So likelihood of confusion disbars trademark registration. It's also the same definition, legal definition of trademark infringement. So what do I mean by that? Well, we have the US Patent and Trademark Office. It is chartered with administering and registering trademarks. It uses the legal test called likelihood of confusion to decide whether it's going to register a trademark. Then we have the judicial system, federal courts, and federal law. They use the same exact legal test, likelihood of confusion, on whether a lawsuit is going to prevail, whether a plaintiff, somebody suing somebody else, will prevail on the merits. They use likelihood of confusion. So it's important to know this. And basically, the test is, are they likely to be confused, mistaken, or deceived as it relates to the commercial source of the product or service? And when we talk about similarity, there's two main issues. One is similarity of the mark itself in sound, look, meaning, or commercial impression. I don't normally talk about commercial impression much, but I usually talk about sound, look, or meaning. And this can be confusing to people because you can have stuff like synonyms will be similar in meaning, translations similar in meaning. We also have the issue of the product or service itself. And everything I'm listing here relates to products that I think are different, but that have been ruled to be similar. So in trademark law, coffee is similar to donuts, perfume similar to suntanning lotion, go figure. Website is a similar thing to a retail store, kind of understand that. Expensive watches, similar to luxury cars, that I don't get. How can people get confused between a luxury car and a luxury watch? I guess the answer at the end of the day is luxury tends to be its own kind of market or channel, and therefore some confusion can rely in that area, apparently. So synonyms, I mentioned that. Box can be similar to cube. Abbreviations, lux versus luxury are going to be similar. Translations, red, rojo, words and made up words can be similar for trademark law. And a lot of the millennials like to change the number 8 for ATE, for example, which is what I've done here. These two words would be considered the same for trademark infringement purposes. And if you have the word translate in your word trademark and somebody else has abbreviated it, that's somebody you need to go after and deal with. The other thing is words found in the same or similar industry, even though they're very different words, can be considered related, like athletics and running. Those are going to be considered the same words if we're dealing with the athletics industry, for example. Different forms of the same word, like adaptive and adapt, even though I sort of view them as very different words. The first word has a lot of prominence, by the way. So if you have one word or two words in your word mark, and somebody goes and stuffs them in a longer sentence, well, it still doesn't matter because that first word of yours is really important. So imagine if I said I came up with a restaurant called Family Fun at McDonald's. Well, right, McDonald's is that first word, only word, you know, very significant. And just because I bury it in a sentence somewhere isn't going to really matter, and it's going to be a problem. The other thing, and I mentioned that just in, you know, I use McDonald's, but this would be another example here where I'm using the word Google. I can stuff Google in a sentence here and it still doesn't matter. That can be considered confusing and therefore create a likelihood of confusion. The one thing I want to tell you, though, to help you analyzing this is if you see one of your words that is in another trademark or being used, what I want you to do is pretend the descriptive terms aren't there. So let's say your trademark is Larry's Funhouse, and you have a children's playroom. Well, the word funhouse is probably descriptive. So you don't want to be, you know, going after people using the word funhouse, but you do want to go after people using the word Larry's as it relates to children's activities, you know, playhouses, funhouses, and things of that nature. So you care about the word Larry's. Same thing with their mark. So you want to get rid of the descriptive terms, just pretend they're not there and see what's left. And you want to compare what's called the distinctive versus the descriptive terms to see if there's a potential likelihood of confusion. So finally, we're almost done here, and I believe we're going to have another talk briefly by somebody. I want to remind you that to monitor, that's the number one issue. And you monitor by going to this link I have right here, test2.uspto.gov. And what you want to do is search for similar marks in sound, meaning, or look. So if you have, you know, a couple of words that can be easily translated into Spanish or French or Italian, you should do that. You should put a little list together that you just keep track of that are, you know, synonyms, root words, things that are enough changes. And I want you to look for those in tests. You also want to tie it to the relevant class code so you don't get too large of a list. And you could do that with the structured search in tests. The only issue is, you're going to get a lot of hits back. And what you want to do is eventually try and, take some notes or record. So once you investigate and determine there isn't a problem. The other thing is you can search for active versus canceled or abandoned applications. That'll help you reduce the amount of hits that come back to you. You also want to do searches on Google and Bing and relevant social media, Facebook, Instagram, LinkedIn, Twitter at the least. If there's other social media out there, you want to maybe monitor that. Quora seems to be a bigger deal lately. You might want to do some searching there, although a lot of Quora posts will be available on Google, and then Reddit seems to be a big deal too. So you might want to look there on occasion. Or you can just hire somebody to do this for you. And the only issue with this is two things. One is you need reports that are at least monthly or ideally at least twice a month. And I mentioned that earlier. That's because we have a 30-day window for oppositions. And so you need enough time to respond to submit an opposition. So what you want to do is find a service that is cost effective, number one, and then two, turns these reports around quickly enough for you. And more than that, you want them to be able to provide someone to help interpret results and or be available to you if you have questions. So you can hire law firms, including mine. We have a service, but a lot of lawyers will do all of this for you, but it's very expensive. So it's best if you can find a service you like that will give you a report, and they're only going to give you changes, deltas. So report number one is going to be the big one, right? Because you haven't done this yet. So you're going to have a bunch of hits. You're not sure. You're going to get confused. And so you want to be able to talk to somebody about that and say, look, I got this 60-page report of 300 possibilities. Do I need to worry about any of these or not? And there might be 3 or 4 that you do need to worry about, and you need to investigate further. Were they using it before you were in a different industry or not? You need to understand who you're going to pick your battle with, and then figure that out. And then the next report that comes, you don't want another 600-page report. You want the deltas, new hits. And interestingly enough, a lot of these reports, hopefully, are going to come back 0. Those are the easiest reports to review. But when there is a problem, you'll get 1 or 2 or 3 hits, much more digestible, but you still want access to somebody to be able to answer or ask questions, as well as to somebody to be able to escalate to. So that's really what you need in order to do this, I think, cost effectively. And that's it. I am done. I appreciate everybody's time. If you have questions, please let me know. And I think we were going to have somebody else speak.
Yeah, please don't hesitate to let us know what questions you have here. Go ahead and put them in the Q&A. We welcome and love questions, so please don't be shy. And in the meantime, I just wanted to take a quick moment to introduce Steffi Rawlings. Steffi, I'm going to allow you to chat. She is part of the New Mexico Small Business Development Center, and we have 19 centers here in New Mexico, including a Procurement Technical Assistance Center, an International Business Accelerator, and a Technology Commercialization Accelerator program. And Steffi, let me go ahead and allow you to talk here. Let me know if you're unable to. I think you're good now.
Can you hear me?
Yes.
Okay. Oh, Mr. Donahue, I enjoy your presentations every time. So I always learn something, so thank you very much. My name's Steffi Rawlings, and I run the New Mexico Technology Commercialization Accelerator. And as Annalena said, I am one of the 19 centers with the Small Business Development Center here in New Mexico. And I'm stationed here in Socorro, New Mexico. We do offer no-cost confidential counseling regarding intellectual property, which includes patents, trademarks, copyrights. And we do talk about trade secrets too. But what we help you do is educate you about the process, and then when it gets really hairy and stuff, we recommend that you move on to a lawyer. So we don't take all your work, Mr. Donahue. So
You guys do great work. You guys are wonderful.
We just and we offer classes also. So just as you registered for this class, we offer our classes on that same events page when we have them. So thank you. The one big thing that we will be having in April is we'll be having a World Intellectual Property Day. So we'll have a big old day of intellectual property. So maybe we'll hit you up to present, Mr. Donahue. So anyway, thank you. If you guys need any help, I'm on the New Mexico Small Business Development Center webpage, nmsdb.org, under locations. Just go to the Technology Commercialization Accelerator. So thank you.
Thanks so much, Steffi. We appreciate that. Yeah, and just wanted to let you all know that we offer no cost confidential counseling services. So don't hesitate to reach out to us. And then I see we've also got one of our counselors here, Anwar. So if you'd like to introduce yourself, let me know. No pressure though, just raise a hand and I'll allow you to speak. And in the meantime, I believe we did have a question come into, not the Q&A, but the chat. Larry, did you happen to see that one?
Yes.
Okay.
Derek asked, how long does your trademark last once it is approved and published? And that's a great question, Derek. The quick answer is it could last indefinitely as long as two things are happening. One is your concurrent use, you're using it. And then two, you do have to file regular renewals. The first one is at 5 years. And the suggestion there is you'd file a renewal plus, I mentioned in my presentation, it's called a, oh Lord, what is it? Affidavit for, or no, petition. It's the incontestability affidavit. So you can file for incontestability as well as renewal on the first 5 years. You can also file for incontestability at any time afterwards, but 5 years is the first time you can start doing that. Then the next renewal is at 10 years. And you need to do that every 5 years or so to keep your trademark active. Otherwise, they will cancel it. That's it. Any other questions?
I think we're good. I did hear from Anwar. He said, huge shout out to Larry for taking the time to support our clients. So yeah, thank you so much. And Steffi, thank you as well. And yeah, I'm not seeing any more questions, so we can go ahead and wrap this up now. Larry, excellent presentation as always. We got a thank you from Derek here. And yeah, we just appreciate your time and your expertise. And thank you all for your attendance.
Thank you, everyone. Take care. Have a good week.